Thursday I'll be in Homer County. I've been down to Marietta, to Green.
Oh, you're going all over.
All over, yeah. Leonard's going to go to the Chili Coffee on Thursday.
Is Leonard here? I haven't seen him.
I
I told you as soon as I heard how nervous Columbus was. That's why I texted you that one day. Like, all right, people are getting legitimately nervous that it was going to blow up. It was going to be a huge thing.
Well, what I heard was that there was the chairman of the Senate. Macaulay. We told the Lake County official, we're not going to give them SHIT. It will blow over if we just do nothing. I contacted.
That's a bad.
Yeah. Okay, you brought along.
I tried to contact the House Chairman of the House, and he won't meet with me.
Probably not. Stevens?
No.
Or not Stevens. Huffman.
Huffman, yeah, man.
That's funny, but that's good for you guys. Like, that's so good. They're so scared. They know their ball's in their court. Pretty crazy.
Yeah. What I'm also being told. Commissioners are meeting again and again. Yeah.
But, I mean, is that legal? Yes. 6:30 comes quick.
Okay. Right? I was thinking of canceling tonight, but I thought, no, that's why we need to be together. We need to practice our liberty. We need to practice our freedom of speech. Because when we say our freedom of speech, we don't go out and we're not violent against the other side, are we?
Never.
So I said, no, we're going to do this tonight. We're just like this little blip in Lake County, a little dot. I said, but no, we're not going to cancel tonight. We're going to say what's on our minds. We're going to say it truthfully. And we're going to say it under our blanket or our flag for freedom. So if you would please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please stay standing for the prayer. In the Father, the Son, and the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory are yours. Amen. Lord, please watch over the Kirk family. A great patriot for our youth is gone today. Take care of his family, his children. Guide him to heaven. Send us who will do Charlie's work. And let us have the courage in Lake County Liberty Coalition to persevere in our work and to be a great, courageous patriot like Charlie. Amen. Father, Son, Holy Spirit, amen. So I guess that's why we're here together tonight, right? Lick each other's wounds together. Or maybe you're here for me. Thank you. So our first speaker tonight will be John Ewer. Who was at the Lake County Liberty Coalition picnic? Okay, so this is might be a little redundant, but we have more information. How many people know about smart meters? Smart meters on our houses? Mm-hmm. Okay. How many people have opted out of their smart meters? What are you paying to opt out of your smart meter?
Nothing yet.
Nothing yet.
It will be 30 though.
Okay. How about you?
It was a long time before they started collecting, but around $30.
Okay. Anybody else? Paying? True story. I was tutoring last week. A gentleman came to the door of the women that I was tutoring at, Christina Barber's house. She gets to the door. He says, I'll be in the back putting in your smart meter. She goes, wait, I opted out. And he said, oh, well, I don't have the paperwork here. She goes, no, I opted out. And she goes, I'm paying $28 a month. My head catted. I'm like, you're paying $28 a month not to have a smart meter. So I jumped off away from the table, and I said, what if she wasn't home? Like, because I was there. Like, you know, like, but I don't answer the door. If I'm tutoring, I don't answer the door. And he said, well, I said, you would have just installed it. So they're not checking to see who's opting out of it. So that was my smart meter story. And she's paying $28 a month not to have it. So that's not an option, right? That's not an option. That's, I call it communism. Either do this or you don't, or you do that, and it's over with. So John is going to talk to us tonight about smart meters. Why not? And you're going to make your own decision. John Ewer, thank you very much.
Thank you, Nancy. Thank everybody for being here tonight, especially Nancy and Debbie for making this all possible for us. Again, as Nancy had mentioned, I'm going to be talking about smart meters. How many of these, you've seen this? Does it look familiar?
Yeah.
You got these in the mail?
Yeah.
Smart meters in your neighborhood? Okay. I began talking about smart meters in Colorado, and we did that for a couple of years, and now we're here. So we're kind of like globetrotting around. People know what's going on. So I'm here just to inform you, give you a little bit of information. It's your decision. I'm not trying to influence the decision. I'm just trying to help you to make an educated decision whether you want this or not. Okay? Well, if I turn my camera on. So, okay. All right. So, retired master technician for Time Warner Cable, 14 years. What that means is there's probably about 2% of the technicians in that company that have reached that level. Okay. What that means, if you look on this side, you've got 8 certificates. That's all from school. That's all the schooling I went through. The other 8 are the accolades that I received from the company. All right. What are smart meters, how they operate, and your right to refuse. Now this is all familiar to all of us, okay? This is an analog smart meter. This is what we're all used to mean and how much they're going to be charging us every month. Okay, this is a digital smart meter. And you'll notice, like, I don't know if my pointer's going to work. It's constantly sending and receiving data. Now, there's 2 different types. There's a regular digital meter and there's a smart meter. Okay, now if you don't see that on your meter, if you just see this, that means it's just a digital meter. It's not sending or receiving any information at all. Okay? But if you're seeing something like this, we're getting these things put on our house. Now we're talking about Surfside area. We live in Surfside. And they're saying, they just put this thing on my house yesterday and I feel sick. And what it does is when it hits you, it turns your whole body into an antenna. All right? And it travels on the outside of your skin. And the way it enters your body is through your eyes. Because your eyes are the weakest point. And your eyes are connected to your brain. So it goes right into your brain. They're collecting data, they're sending it back and forth, minute by minute. And what it's doing, it's letting electric companies know when you're at home, when you're away, what appliances you're using and when, your daily routines and habits. It's tracking everything. They're telling you it's not, but it is. Okay? They're telling you it's a microwave, it's not. They're telling you it's operating at 548 megahertz, it's not. It's in a gigahertz range. And when you start talking about gigahertz, just imagine 1 with 17 zeros behind it. That's a lot, especially when you start talking about a human being. Our bioelectrical system that keeps our heart beating, our brain working, everything is running at 7.4 hertz. That compared to a bill with one of these things, you have no recourse to pay that bill. We've got reports of people getting hit with a $1,000 bill the first month they had this thing put on their house. And when they tell them, hey, we're not going to pay, fine, don't pay, we're just going to shut your electric off. So you really have no recourse other than to pay the bill. delivering that to your house, frequency gets in, frequency gets out. It's called ingress and egress, and that causes noise. Noise causes fluctuation in the frequency. Fluctuation in the frequency is going to cause them to misread your meter. You're not going to get an accurate reading. And there's no way you can get around it. Like I said, 14 years in the business, there's no way you can get around the algorithms and just simple mechanical measurement. The biggest difference is that the analog meters, the old ones with the dials on them, they had built-in surge protectors in them, okay? So that if you had an outage, and then the outage came back on, and when that surge comes through and that electricity hits your house, that surge protector would stop that from... Smart meters don't have that. And the reason they don't have it is because they've got what they call switching powers. And if they put a surge switching power supply stops working. So we've got many reports that people, they didn't pay their bill. So they got their electricity shut off. And then they got their electricity turned back on, and the surge came and boom, now they got a fire. So, and when they talk to the electric meter companies about, oh, no, that doesn't happen. That's not our fault. Okay? So why fix what isn't broke? Okay? You have a right to refuse. Many regions, they'll give you the opt-out form, but Debbie talked about it, and Nancy talked about it. They're charging you to do this. Nancy referred to a state of communism. I referred to it more as a state of extortion. And I got on the phone with the company, and I was reading them the Riot Act. I was like, hey, look, you know what? This is extortion. You can't. That would be like me starting a company in our neighborhood, promoting a product nobody wants, and because you don't want it, I'm going to charge you because you're not buying it. Mm-hmm. And now she said $29. When I opted out of mine, it was only $20. So it's gone up, and that's what I'm telling her. Something's going on. If that price went up, something's triggering that price.
That brochure you have?
Because there's a lot of elderly out there. When I was in Colorado, they didn't charge us for that. You can opt out and have a meter change and stuff like that, and they didn't charge us for that. But they're doing it here. And they passed legislation to make it legal. That's why bottles online anymore. Because they passed legislation in Ohio to make it legal for utility companies to charge you for a product that you don't want. It's insane. It is. Okay, now we're going to get into some potential health hazards. They're telling them it's all in their imagination. These are, go home and take some aspirin. Because the doctors don't know what it is either. Nobody knows what this stuff is, okay? Headaches, migraines, dizziness, vertigo, insomnia, mood swings, the whole 9 yards. Some other, now we're going to talk more about this too. We're talking about heart. Hear it again. Heart, cardiac, heart, oxidative stress, cellular damage, DNA strand breaks. My brother-in-law moved from Kirtland, he lived in Kirtland, to San Francisco. 3 months later, he was diagnosed with mantle cell lymphoma, which is a very rare, almost fatal all the time, type of cancer. And it's caused from a DNA strand break. So what caused it? He's looking outside his window, and he's got a 5G tower right outside the window where he's living. Now, we just had somebody on next door talking about it today. They were just diagnosed with mantle cell lymphoma. It's like, what are the odds that... And the only way you can get this is through a DNA strand break. It's not like you smoke cigarettes or drink it's a DNA strand break that causes it. So we're starting to see a very, very rare type of cancer now starting to surface. What's changed? Okay? Mitochondrial dysfunction, accelerated cellular aging. It's bad. Over time, chronic illnesses, cancer, Alzheimer's is linked to Alzheimer's, Parkinson's, chronic fatigue. And again, you go to the hospital and the doctors can't diagnose you with it because they don't know what it is. I don't know. Here, take this pill. Get some chemo. I don't know. Children are especially at risk because they got thinner skulls. Their nervous system is still developing. They got smaller bodies. Elderly, the same thing. They got compromised system. You got people that, you know, they're dealing with cancer, they're dealing with these other chronic illnesses, and they're just putting them on there. They're just putting them out there. Can't see it, hear it. Every second, you know, it never shuts off. Low dose exposures matters as much, if not more, of a higher dose because it's extended over time, 24/7. Okay. They emit pulses day and night. And house, it plugs directly into your wiring. Okay, so it turns your whole house into an antenna, not just where the meters are at. All right. Back, there's only maybe 15 or 20 of them, so if you want one, grab it. But the Bio Initiative Working Group, they did a real good study of it. I mean, the problem with this is a lot of the information now is being censored. Doesn't make this information any less relative, because it is. I mean, what's going on with smart meters hasn't changed. So the information hasn't changed. I've had a lot of people, oh, this was back in 2017 or 2019 or whatever. It doesn't matter. The technology. There's so much space junk up there right now from satellites and everything else being launched that they can't even find a launch window anymore. Every time they send something up, it crashes into something else. In the past 4 years, the number of what they call LEOs, it's a low Earth orbit satellite, has doubled from 7,000 to 14,000. Who do you think's responsible for that 7,000? Anybody.
China.
Elon Musk. In the Clark's Belt. Low Earth orbit satellites don't do that. That's why they got to launch more of them, because they got to communicate with each other. Right? So they're going out of their way to do this stuff. Okay, I'm almost out of time, so I am going to open it up for Q&A. Fire away.
It said something about some of the symptoms are mood swings and irritability, and you know, we don't really tie it up to the grid much, but I'm wondering. I'm just kidding. No, my real question is this tied to like ESG scores? You know, where they can kind of shut you off if you're not subscribing to their equity and government's kind of.
They'll shut you off for not paying your bill. Okay, that's it. They're in it to make money.
I mean, I can see it being eventually being part of that system, though,
Yeah.
where they, and not your credit score.
Finish this total rollout of these smart meters in Palisades, California, and all of a sudden all the houses went up, and they wouldn't let anybody back in there. You couldn't go back in there and go through your stuff to see what was left. Go ahead, John.
Hey, John. Yeah. One thing. So what they'll do is use these smart meters, because again, the two-way communication. There's a little relay in there, and they'll just selectively just brown out certain residences, whoever they feel is using. And like you said, it tracks all the appliances. Everything can be tracked in there. So this all.
Natural vibration that's in our body that's responsible for keeping our heart going and our brain going, and he said it causes all kinds of problems on a cellular level. And people are, like I said, they're reporting symptoms. Doc, I'm sick. I don't know what's wrong with me. My stomach is upset. I can't sleep at night. I can't remember anything. I'm starting to hurt everywhere. And the doctors are going, oh, you know what? You're just getting old. Go home. And he had the money, so he paid for it. You know, it wasn't free. And so you have this going on, and they just keep turning a blind eye to it. It's all about what it's called the Internet of Things. They want everything connected to the Internet. It's all about smart meters and chips and this digital ID thing, and they want total control over everything. Then you start seeing things like the opt-out. Okay. Now, what I have discovered is a group called the Empower Movement, and through the Empower Movement, they have what is called a notice of liability, and we talked about this before, where it's a thing, where what they'll do is, if you send them your zip code, they'll tell you who's in charge of making sure the legislation goes through, making sure who's in charge of the utilities companies, and these types of things. Because what they found was, when you go after the company itself, you're not going to win, because they got too much money. All right, so they're just going to beat you to death with their lawyers and the fees and these type of things. So what this does is it lets you go after the person, not the company. And when you start sending these notices of liability, say if I send one, John sends one, this, we get 15 or 20 of them hit the same desk. These people are like, man. And what it does is, what this says is, if something in my house as a result of this smart meter being on my house, any power, they don't want any part of that anymore.
Any kind of movement going against this?
That's what we're doing here today. We're getting out here, we're educating people, letting them know what's going on, we're giving them options, different websites they can go to.
But just like what we're doing about the real estate taxes, is there anything like
what's our call?
System. So you could do that. You could notify, your elected officials and say, hey, look, these smart meters, we've been learning a little bit more about them. We don't like it. And what's worse is we don't like this opt-out fee.
Yeah, maybe Matt can answer some questions about that. He's smiling right now. I don't think Painesville City has a smart meter.
I think they did pass an ordinance about them, so I think they're coming.
Yeah, they're installing them in waves.
Yeah, I was going to say I don't see that. Second thing, what about generators? Because you talk about shutting electricity off. Generators.
Yeah, your generator's tied right into your house.
Ohio, I think they're coming up with a House bill, I think it's 427, where they're going to have the ability
Of power, they'll up it. They'll up your fee. They're not going to cut you off. They're going to charge you more.
Did you get in
Go ahead.
I heard that they're actually on that same bill, they're going to control your thermostat. Because I know I go to Atlanta, Georgia's the place that controls their.
Because you talk to people about it, and either they don't care, or they think you're a tinfoil hat wearer, or they're too busy with their own lives to in. Because we lived in a condo in Fort Collins, and the smart meter bank was right on the outside of our house, on the other side of our TV, and I ordered some sophisticated equipment to measure where this stuff was coming from, and I found that the lines, now we had to take measurements, they were off the charts.
I know that the neighbor next door has got to go through my basement in order to put the cable in, so I got to figure that the electric wire's got to be in my house, in my basement, so I'm getting at least his, right? There's 2 other people attached.
Mm-hmm. So I'll hang around for a little while if you have more questions, because we got a couple more speakers, and I'm already over my time.
My girlfriend's in an apartment, and I said, where's your smart meter? She didn't know she could volunteer to opt out, because it's when you're paying your electric, you can't. She goes, I said, where are your meters? She goes, they're all in one room for the whole apartment complex. That's so dangerous, it makes me sick.
Yeah.
Right?
Yeah.
It would be. Yeah.
It's
Now,
terrible.
I just want to say, if anybody wants to opt out and you're afraid that you're not going to, they're not going to pay attention, I actually put a sign on, because they don't itemize them out. So my last bill was the same.
Yeah.
But I didn't know that you can actually have a meter without being smart meter. Now I have to look. Maybe they're just switching out all the meters in the area.
Because we have a digital meter on our house, but it's not a smart meter.
So it's okay to have a digital meter.
Right.
As long as they
You
don't
just
make
got to
it
make
smart.
it doesn't have that
When
two-way
I opted
communication.
out, they didn't even switch the old meter.
Yeah.
Is the talk show host. So I called an open mic. A little bit of knowledge I got on, right? He said he thought it was nuts. This is a conservative talk radio show. He's like, no, you're wrong. It's not that much it's not that much power going through. No. I was like, wow. He wouldn't even listen to me. And then the next guy called and said, yeah, she's wrong. It's just like a microwave. It's no big deal. Okay?
That's what they're telling you. It's a microwave, and it's not. It's not a microwave.
Right. Well, what I'm saying is that limited information, when I called the radio station, I thought, well, get a conversation, go open mic, like I have time to do this. But it got me mad. And the people called after me like, yeah, she's wrong. It's more efficient. It'll save you money. They don't have to knock on your door to come in your backyard. Your dog won't be barking at someone in your backyard with your meter. I thought, wow. So when I had John back, so now we have more to fight with. So that letter of liability is very important, isn't it?
It's notice of liability. You go to Empower Movement, and there's just
It's a whole community, I think.
It's on here, right?
Yeah, I think they're up to 2,600 members now. So it's not a little thing. It's starting to get a little bit of traction, but it's giving us some tools to fight back.
There's a lady, I don't think she's here tonight. She's from Colorado. She said that her husband worked for the Federal Reserve in Colorado, and she said that they were treated very, very well as an employee of the Federal Reserve. Very fancy condo. She said, you name it, I had it in my condo. It was a 2,000 square foot condo. She goes, I couldn't wait to leave after 3 years. Smart meters made her life hell. She said she was at her electric stove. She wants to put in her sweater into her dryer. She's entertaining, get her outfit ready. Wouldn't let her do it. Too much power was going out. She said she had to plan her life for 3 years of what she was going to use. Brownouts are very common. They think that's the way you save the environment. That's another part of that BS. So I had talked to somebody who lived through smart meters, and she says, I live here now. I love it. She goes, I have a little farmhouse. She lives out in Madison. She says, she puts on lights. She puts on her gas dryer. She puts on whatever she wants to put on, her electric stove, gas dryer, and she goes, no one tells me what I can or what I cannot use, or what I want to plan every day. I just get up and I do it.
Not yet.
Pardon me? Not yet.
Not yet.
Right. So she called me before this meeting. She goes, I can't make it, but please tell my story. I said, okay, I would. I did.
You want to use my computer?
You packed it up already.
No, that's fine.
I don't want to.
I don't know if you recognize Matt. Who was here for the commissioners' debate 2 years ago?
Oh,
Yeah, he was our moderator. Matt, he was our moderator. Yes. He navigated three politicians. That was really hard to do.
Oh, you got the flash drive. That's important.
But I can get started here while we're resetting up again. So I'm assuming all of you know what federalism means, right? Mm-hmm. Right. That we're a country that is made up of states with a constitution in which we've delegated certain powers to a national government, and that the difference between the powers of the national government and the state government is what's referred to when we talk about federalism. There is a component of that called judicial federalism. And so judicial federalism is a recognition that in our state, in all of the states actually, each of the states has their own constitution. In addition...
Okay, Matt, you're up. There
Thank you.
You're welcome.
So let me pull up.
Now, let me do this.
So it's a recognition that our Constitution means something. Now, throughout your whole and thinking back to your civics classes, have you ever learned anything about the Ohio Constitution?
No.
But you probably learned all about the United States Constitution.
Yeah, right.
What do you think plays more of an impact in our daily lives between the two?
Ohio.
The state, right? Because that's exactly what our founders actually thought. We talk a lot about the Bill of Rights. Do you know why the framers in the original Federal Convention of 1787, why they didn't include a Bill of Rights? They thought, why do we need it? We have state constitutions, most of the state, not all, but most of the state constitutions in 1787, all of the states had a Bill of Rights. They thought, the states will protect us. We don't need to have an additional protections against the federal government. The states will make sure that the federal government doesn't get out of control. We will have recourse to our state governments when the federal government gets out of control. That's why we don't need a separate Bill of Rights or a federal judiciary to keep the federal government in line. We have the state governments.
They elected the senators at one time.
They did. So, anyone know what common law means? By a show of hands? I've got a couple.
Like common law marriage.
Yeah, right. Common law marriage.
So this presentation is called "The Common Law Restored: How Independently Reviewing the Ohio Constitution Can Best Protect Our Rights." This is based off of a forthcoming law review article that is going to be published in Capital University's Law Review that I have authored. And so the reason I started doing this research is due to a case out of our state Supreme Court called State Ex Rel Cincinnati Enquirer versus Bloom, where the Ohio Supreme Court, this is a line they've said several times before, but I'm hoping this time they mean it, that the Ohio Constitution is a document of independent force. And in this case involved, Nancy didn't go through my whole background, but I currently serve in our county's juvenile court system as a mediator and a magistrate. And this case came out of the Hamilton County Juvenile Court. It involved a juvenile who was involved in a homicide. And unfortunately, the juvenile ended up dying young, dying before his case was even concluded. And because the homicide was big news down there, think of think of what happened today, right? Like, it was in Cincinnati. It was a big deal. It was kind of a major shock at the time that this kind of thing happened. And the case was never resolved. And the Cincinnati Enquirer wanted to report on the details of what happened. But under our state law, juvenile cases, once they are concluded, and in this case, the case was concluded by the death of the juvenile before he was brought to justice, were automatically sealed. And the Cincinnati Enquirer wanted the court records released so they could learn what actually happened, what the police actually investigated, everything that happened with this case. So they sued, and our courts up to this point, in regards to access to court records, did not follow our state constitution. They followed federal jurisprudence, meaning what federal courts have said, when across the country litigants have filed to get court records and claimed a right under the federal constitution for court records. How have the federal courts recognized a federal constitutional right to court records? Believe it or not, they found that right in the First Amendment. Now, I don't know if any of you have the First Amendment memorized, but do you guys know where anything in the First Amendment has to do with access to courts? No, there's nothing there. And under that federal jurisprudence, courts across the country have said you don't have the right to juvenile records. And so the Cincinnati Enquirer pointed out, there's this, where's the pointer aspect of this? Is it this?
It's right on the little red.
There you go. I'm moving forward. Okay, here.
Yeah.
There's this provision here of our state constitution. All courts shall be open. And the Cincinnati Enquirer believed that meant not only could you go into all courts, that it was publicly open for people to walk in and out of, but it meant that the records of the court should be open and available. And the Ohio Supreme Court agreed. And they basically said that we need to interpret the Ohio State Constitution on its own, as its own document, not as just a corollary to the federal Constitution, or what happens in effect nowadays is whatever federal courts say the U.S. Constitution means. So that the federal guarantees of the Ohio Bill of Rights have undiminished vitality, and Ohio courts are not bound to walk lockstep. In other words, just whatever the federal courts say the U.S. Constitution means, that's what we're going to say the Ohio Constitution means. That's what lockstepping means. And that when a judge says that, they are violating their oath to support the Ohio Constitution. When I was sworn in as a magistrate, I swore an oath to uphold both the United States Constitution and the Constitution of the state of Ohio. If I'm just following the United States Constitution, I would be ignoring my oath to the Ohio Constitution. And so what the courts announced in this case, which they hadn't done before, they have independently reviewed the Ohio Constitution in the past in a very small number of cases, but for the first time, and this is a big deal, they have said that now they will revisit past precedent. So they are willing to overturn old cases where the courts have said the Ohio Constitution means whatever the U.S. Constitution says. So as a lawyer, this excites me. This is something that, like, I'm a little weird in that way. I get giddy about the fact of creating new law, creating new precedent. This is something that, as conservatives living under a system that has been dominated by liberal thoughts on what the law is, what the Constitution means, this is a golden opportunity. So I wanted to look into this. And so I started about this: all courts shall be open. But this provision of the Ohio Constitution, Article 1, Section 16, has a lot more to it. It goes on to say, every person for an injury done him in his land, goods, person, or reputation shall have remedy by due course of law, and shall have justice administered without denial or delay. Suits may be brought against the state in such courts and in such manner as may be provided by law. So I started looking into this, and the first question I asked is this one of those provisions that the Ohio courts have basically been in lockstep with the federal Constitution? And no surprise, it has been. That there is a case from the late 19th century, Adler versus Whitlock. It was a case about where a bunch of a coalition of barkeeps, essentially, challenged the state tax on liquor. And one of the challenges of it was based on this, remedy by due course of law, that they basically said that the state was illegitimately taking their goods, right, their money, in the form of illegitimate taxation, and they didn't have a remedy under due course of law because the tax was so complicated. It was completely couldn't understand it. It was basically a due process violation. And the court in that case said, well, due course of law, that sounds like due process under the 14th Amendment of the Constitution, and we've got federal courts that say you can't challenge taxes under the due process clause, so you can't do that here. And ever since, Ohio courts, whenever a litigant has brought forth this provision here, the rest of this first sentence, the second clause, after all courts shall be open, they basically have reviewed it under the 14th Amendment due process jurisprudence of the federal courts. So Justice DeWine, who is the lead author of the Bloom opinion, also has a forthcoming law review article out in which he explains how he would like he and his colleagues on the court to review these types of cases. And he says, first we look at the text, then we look at the history and tradition. So looking at the text here, you'll see that the text of Article 1, Section 16 is very different than the 14th Amendment to the Constitution, which protects all of us in regards to having our life and liberty protected under the from due you can only have it taken under due process. This is talking about something different. This isn't talking just about having our life, liberty, or property taken by the government without due process of law. This is talking about injuries we have. And as our last presentation showed, our injuries don't always come from the government. That we have a right to our land, our goods, our person, our reputation, and if there is an injury to them, we shall have a remedy. and that remedy shall be by the due course of law, and separately, that justice shall be administered without denial or delay. So that just the textual clues give off that this maybe should be treated a little bit differently than the 14th Amendment. So let's look at the history and traditions that arise from this. And they go back centuries. Anyone know who these guys are? You guys ever heard of them?
They took over Rome, basically.
They did. But before they got to Rome, after the Romans retreated from the Britannic Islands, or at least Britain itself, these are the guys who came into England, the Angles, Saxons, and Utes. And why I bring them up is because both at the time of our nation's founding and even at the time our Constitution was passed. Anyone know when our Constitution, our state Constitution was passed? Anyone know? 1851. Our state has had two constitutions, an original one in 1802, a second one in 1851. Even in 1851, in the debates in that convention, our framers of our state constitution referenced these guys. And of course, there's been a lot of historical revisionism over the years to challenge the conventional belief that all of our traditions, our heritage, our legal heritage, comes from these guys. A lot of modern day historians say that's a bunch of, made up stuff. But our founders believed it. Whether or not it's true or not, the fact that our founders believe it makes it relevant for purposes of legal interpretation. That our traditions came from these guys. Now, the earliest actual written recording that we have that we can tie directly to our state constitution, Article 1, Section 16, is the Magna Carta. So to understand why the Magna Carta was written, what those words mean, and the relevance it then has to us today, we do need to have a little bit of an understanding of what was happening in early 13th century England that caused it to be written. Anyone know the story of Robin Hood?
Mm-hmm.
Yeah, that's a true story.
It is well, Robin Hood itself isn't true, but it's based on some real things that happened. Was it all about robbing from the rich to give to the poor?
It was King John's despicable acts.
It was more about King John's despicable acts. It was about robbing from the government to give to the poor. the bad guys in the story of Robin Hood are the government. It's this guy. It's King John. And I know many of the people here might be against the concept of forever wars. So the original forever wars for our history and tradition were the wars between England and France. So I don't know how much you guys may recall your English history. Everyone familiar with William the Conqueror?
Mm-hmm.
Okay, Duke of Normandy, claimed the kingship of England, conquers England from Normandy and France. Ever since that time, the royal household in England had extensive land holdings in France. And even though they were king in England, as dukes of actually a majority of the land in France, they held that in fealty to the French king, which led to a lot of conflict over roughly 200, almost 400 years, depending on what dates you use. And at this point in time, King John had just lost nearly all of the English possessions in France to Philip II of France. And he did not like that because it was his patrimony. He was related to William the Conqueror, who was the Duke of Normandy, and he lost Normandy to the French. And he wanted to get it back. But he didn't have the money to keep fighting France. So what was he doing? He was taking that money. He was throwing people in prison for not giving him the money he needed. He was sending out his thugs to threaten nobles for money and having them beat them up if they weren't giving them money. He was exiling people out of England so he could take their land and then get all the taxation from that land. That in that feudal system, everyone was basically a tenant of the local lord or duke, that he could get those Magna Carta. And one of the reasons we know that Magna Carta is tied to those Angles, Saxons, and Utes is because the people at the time said it was. The main architect of the Magna Carta was this guy here, the Archbishop of Canterbury, Stephen Langton. He said, hey, I don't like war. I don't want you guys rebelling against the king, but I understand that the king hasn't been doing the right thing. How do we keep him on the right path? How do you guys like the idea of holding him to the ancient traditions of our Anglo-Saxon forebears? And the Baron said, we had freedom under that system. That's what we want to go back to. And that's what the Magna Carta meant to them. And so that was signed in Henry III, who was not old enough to govern the kingdom on his own. And so this is what gave the barons the opportunity to actually enforce Magna Carta, as they said to the minor, Henry III, we'll recognize you as king if you uphold Magna Carta. And so Magna Carta in its final form wasn't finalized until 1225, and in its final form, the language that we can now connect to our state constitution is here. And it says, no free man shall be in future arrested or imprisoned or disseized. I mean, that was the word at the time to take property away from someone. Of his freehold, liberties, or customs, outlawed or exiled or victimized in any other way. And this is how we know what King John was doing that was illegal, because they're the things that they're saying now Henry III can't do anymore. Neither will we attack him or send anyone to attack him, except by the lawful judgment of his peers or by the law of the land. And then the second sentence is what correlates to that justice being not neither delayed or denied. To no one will we sell, to no one will we refuse or delay right or justice. This was another thing King John was doing to earn money. So this is another thing I need to talk about really quickly to understand what the common law is. So at the time in England, every lord was a court unto himself. So whether or not you were a duke, you were an earl, if you were an abbot, if you were a bishop, you held your own court. You had the right to administer cases and all of your property. And everyone on your property was basically a tenant of you. And there are different types of law you would administer in your court. There was feudal law. There was ecclesiastical law that would be administered by the abbots or the bishops in their territories. There wasn't understood. They still had Roman law. Those laws were kept on. Whether or not they, in what cases they used it is something up to historical debate. But they still had an understanding of Roman law that they would sometimes apply. There were the Germanic laws from the original Angles and Saxons. There were territories that were conquered by the Danes over a period of time in the early Middle Ages, so there was some Danish law that was still being applied at the time. But they had all different laws, and one of the ways that the Norman kings enforced their authority was through a writ system, in which case the king was claiming universal authority to administer the law over and kind of on top of each of those local courts. And how he did it was people would basically make a pleading to the king. Is everyone familiar with pleadings in the legal context? That's like the initial complaint that you would file in a court. And this is how our concept of complaints, it derives from this system, where someone would make a pleading to the king, and then the king would issue a writ to a local authority, typically the sheriff, and say, this is what you need to do to remedy this complaint. And that is how a common law, a law that was common throughout England, developed. But what John was doing is he was selling these writs. it was a way for him to get money to have his war with France. He was selling them to the highest bidder. And then if there was someone he didn't like, he would deny the writ. He would deny that person justice. Or he would sit on it and just not act on it. He would delay justice. So that is the connection to our state constitution, is that those violations that happened way back in the 13th century. So I want to tell you a little, so we're going to fast forward a few centuries, because the next time we really see this brought up, and this is Edward Coke. At the time of our nation's founding, he was known as the preeminent scholar of the common law. And he had his own battle with the king. In this case, it was King James I of England. That would make him 6th of Scotland. But he was a jurist. He sat on a court that administered the common law in the early 17th century. And what he believed was that the common law took precedence over the king's own will. So that if the king wanted to do something but it violated common law, he would say, king, you can't do that. And as you can imagine, the king didn't like that. And so the king was trying to be politically savvy. Instead of just going after him or arresting him or kicking him out of his position as a judge, he promoted him. He promoted him from a common law court to a court in equity, which is a different type of court in which there are different remedies, different procedures. And if you guys are familiar with all there's been a lot of noise about equity recently, because we had a good United States Supreme Court case that limited the equitable powers of the federal courts if they follow the Supreme Court, but that basically said there's no such thing as one of these universal injunctions. That comes from these courts of equity. But the king thought that by taking him out of the common law courts, he wouldn't be able to enforce that common law over his will, but he still caused trouble for the king, and so the king did end up kicking him out, firing him from his job as a judge. But that gave him the opportunity to write a treatise of the common law, which is what all of our founders who were attorneys, and even some who weren't attorneys, that is what they studied at the time of our nation's founding, was Coke's interpretation of the common law. And I'm not going to go through all of this, but it basically summarizes what the rights people had under the Magna Carta. This is a little bit easier to read, so I'm going to skip to Blackstone. William Blackstone was a contemporary of our founders, but was a jurist in England at the time. And what he he's the guy now that our federal courts will more likely cite Blackstone rather than Coke when talking about what the common law means. And he separated rights into two different categories. There are absolute rights that exist in the state of nature, and those are your personal security, personal liberty, private property. So personal security includes the right to your life, your health, hearkening back to our last presentation, your reputation. Personal liberty is about freedom of movement, or another way of saying it is freedom from restraint. And then the use of private property. There's a free use, enjoyment, and disposal of your acquisitions without interference or diminution except by law. Again, hearkening back to our last presentation, your house is your property to use and enjoy as you see fit in a state of nature. And liberals seem to have a difficulty separating these two concepts, as was apparent by Senator Tim Kaine's remarks. This is what God gives us, right? But when we're in a community, how do we keep and protect these God-given rights? That's where this concept of subordinate rights come from. This is where we agree with each other how to protect these. And that's where we have the right to a remedy, the right to a court of justice for the redress of injuries. But it's also, another subordinate right is the right to a jury trial, the right to only have taxation with representation. Those are subordinate rights, but they don't take away our absolute rights. They help enforce them. These come from God. These can come from government. And Tim Kaine needs to relearn that lesson, but I digress. So this is something that was important to our founders. It's one of the reasons that we separated from Great Britain. One of the reasons I think the court should be quoting Coke more than Blackstone is because the reason that we separated from the mother country isn't because of the king and we were rebelling against monarchy. We were actually rebelling against a majority rule of parliament, a parliament that did not include direct representation from us as colonies, but thought that it was above the law. One of the things Blackstone was a big proponent of was this concept of parliamentary supremacy, that if Parliament said this was law, that law could countermand what the common law was. Coke, on the other hand, separated categories of law into customs, statutory law, the laws passed by Parliament, and common law. And he had them in that order: customs, statutory law, common law at the top, and common law superseded statutory law. Parliament didn't think that way. Parliament thought that if they passed it, they could violate the common law rights of the colonies. And the colonies fought against that. You can't violate our common law rights. And what are some of the things Parliament did at the time that violated the common law? We don't have to guess, because they put it in the Declaration of Independence. One of the things that they gave as one of their causes for independence was the fact that Parliament abolished the common law in Canada. I don't know how many of you know this. If we hadn't rebelled, what original colony would we have been a part of in 1775? Anyone know? Canada! The king extended Canada's boundaries into the Northwest Territory and then abolished the common law. So all of these original, a lot of our founders, George Washington included, that's how the French and Indian War started. You guys all know that? It was because George Washington was sent by the governor of Virginia to claim Ohio for Britain rather than France. And George Washington had a lot of property, invested in a lot of properties along the Ohio River to include the southern portion of our state. He didn't want the common law to be abolished here. That was his heritage. That's how he guaranteed his rights against tyranny, and that's how the other framers thought as well. And then we all know what the English did to the colony of Massachusetts. That after the Boston Tea Party, they abolished the Massachusetts government, treated it as being in a state of rebellion. So they were obviously taking away the common law rights of all the people of Massachusetts based on what a few guys did in the Tea Party. So that was one of the reasons we rebelled and declared our independence. So the next place we see the same language as in our current Constitution is in the Northwest Ordinance of 1787. So as our Constitution was being debated, the members of the Confederation Congress put this together. And what I want you to look at, I don't know if you ever were actually taught this, if you were ever taught in school about the Northwest Ordinance. I found this very interesting. The opening of the ordinance is that these articles shall be considered as articles of compact between the original states and the people and states in the Northwest Territory, meaning us, we're Ohioans, forever remain unalterable. Forever. That means now and later until forever. Unless by common consent, which means not just our consent within the territory, but also between the national government or the peoples of our sister states, all of them. Oop, I don't know what just happened.
There it is.
There it is. It's back on.
Oh, I don't know why it went all the way to the end there.
You might have pushed it by accident.
Yeah. We could probably just start the slideshow again. Okay, so for purposes, again, a lot of our rights are listed in here, but for purposes of Article 1, Section 16, I just want to focus on this. And of judicial proceedings according to the course of the common law. So when our original delegates to the Confederation Congress set up our system of government, they intended the common law to apply here in this territory forever, unless we as a people and the federal government agreed otherwise.
Ran out of battery.
Yeah, that's okay. I'm loud. Wait.
Yeah, I can hear you.
That's done. You guys can hear me anyways. So in 1802, we passed our first constitution. That language in Article 1, Section 16 was basically the same in 1802. It was just in a different provision of the Constitution. It was moved up in the 1851 Constitution. But that language wasn't something that our original state framers just came up with. It was found in most of the other state constitutions. We actually took it from Tennessee. Tennessee took it from Kentucky. Kentucky took it from Pennsylvania. Pennsylvania took it from Massachusetts. And a few of the other states had very similar language. So how was that enforced originally before the 51 Convention? There were a few ways. We're causing flooding, because to build a mill you end up having to dam a river so that the force of that river can be used to generate energy through the mill, right? But what happens when there's bad rainfall and there's that dam there, and there was, for whatever reason in Massachusetts, I don't know the topography or geography there very well, but for whatever reason there was a proliferation of suits of people suing mill owners for damages to their property. The Massachusetts legislature said, this is getting out of hand. We need to have a better system of administering the damages to these suits. So rather than people suing under the common law, we're going to set up this alternate system for people to get damages for when their land is flooded by mill owners. And one of the mill owners didn't really like it, and because as you can imagine, whenever a legislature tries to come up with its own remedy, have you guys ever looked at the Ohio Revised Code? It's not good reading. It didn't make sense. And so one of the mill owners sued, or it was actually one of the, some guy who had his land flooded, sued a mill owner and wanted damages at common law. Common law is easy. We know what it means. We know how to assess damages. We have a jury to do that. I don't want to go through this process of whatever the legislature set up. It's confusing. And so this case went all the way up to the Supreme Judicial Court of Massachusetts, their version of the Supreme Court, under the Massachusetts version of the right to remedy provision that's found in our Constitution. And they basically said the legislature can change common law, can take away a common law remedy as long as they provide another remedy, even if that remedy is confusing and not very good, because you can end up voting other people in to change that law and make it better. So that's called the quid pro quo approach to this constitutional provision. Some other cases that I found were in regards to judicial delays. Another common thing that we still see today is people not wanting to be liable for some of the commitments they make, and especially when there's a economic situation, like a lot of cases I found came out of the panic of 1837. We call these economic downturns depressions now. Back in the 19th century, they were panics. A lot of people didn't have money to pay on their mortgages anymore. Banks were coming in and seizing property. People were complaining to their legislatures. It's not fair. I didn't pay my mortgage and the bank took my home. You can't kick me out of my home. You need legislatures, you need to do something for me. A lot of legislatures then passed they suspended judgments relating to foreclosure. So if a bank came to try and foreclose on your property, they were granted the right to foreclose on your property. They wouldn't be able to actually take another person's home for a period of time. We had a lot of cases from this point basically overturning those statutes because it was justice delayed. If you are suspending the execution of a legal judgment, you are delaying justice. That it's strictly against this language in all these state constitutions that says justice shall not be delayed. And it can't be denied. I found a couple cases that illustrated how this was. An interesting one that I found was in regards to a case that required, for a particular case, before you could actually file a complaint, you had to come into court, you had to testify in open court as to what your complaint was, rather than just write it down and file it. And then for that testimony to be administered in evidence later at the actual trial for that, you had to have 3 witnesses come in to support that testimony. The court in that case said, that's basically justice denied. You are putting in too many obstacles for someone to have his day in court. There's no reason to come into court and state your complaint orally on the record when you can write it down and if needed have someone notarize your complaint. That's just, the notary in an affidavit is the same thing as testifying in open court. Why have people go through that hassle and then have 3 witnesses to support it? That's 3 too many. You could have 1 person testify to something and be credible. So that was effectively justice denied. So those were the examples that when the framers of our state constitution had as to what that clause meant. And that is how our state should be looking at this clause now, with those examples in mind. So what does an independent Article 1, Section 16 look like? Does it mean the Ohio legislature can abrogate the common law, meaning take the common law away? I think when you look at the history, the full history, going back to Magna Carta, which our English forebears said the king can't do this because it violates the common law. Koch again, the king can't do this because it violates the common law. Our nation's founders, the king and parliament can't do this because it violates common law. That is what this provision was about, was to keep our legislature, our executive branch officials, whether or not it's a governor or a board of county commissioners or a mayor, whoever the case might be, they cannot violate the common law. It's a law that is above statutory law. But at the very least, it means if you're going to take a right away, you have to replace it with something. If we have a right to our bodily integrity and our health, they can't take that away by mandating that we use a particular type of device that's attached to our homes. They have to give us a way to remedy that. It can't just be, you have no choice. So, at the very least, it means that they cannot limit a remedy without offering a replacement. I think it also means that if there are conditions to filing a lawsuit, whether or not those are by statute or whether or not they're by court rules. So, did anyone know that we have an amendment to our Constitution back in the 1960s that allowed the Supreme Court to make all the rules for the Ohio court system? So our Ohio court rules aren't set by our state legislature, they're set by our state Supreme Court. And then each court can then develop its own local rules. But the Supreme Court could be violating the Constitution it's sworn to protect if it creates rules that delay or deny justice. So this is how we take our rights back. The federal government isn't there to protect us in all circumstances. The founders of our state and the framers of our current state constitution did not have that kind of faith in government. They expected us to enforce our own rights in a legal system that allows us access to the courts, to sue when necessary, and that constitutionally we have a right to remedy in our court system when we're injured. And so this is how we take our rights back. It's not by necessarily going to the federal Constitution and the Due Process Clause, but going to our own Constitution. And so I'm hoping that by getting the word out here and more people are aware of it, they know what their rights are, and who knows, we might see some cases coming forth that vindicate this thesis. And I'll take questions. We only got a couple minutes left. Go ahead.
Just as a question, they were talking about that notice to the utilities. Mm-hmm. Is that a legal notice under the common law?
Well, without having looked at it, I can't say whether or not it's legal. But what I can say under this is that if you have a right to remedy to a damage in your person, and these smart meters are causing you ill, you should have a right to remedy under our state constitution for any damages that come from that illness, from the person or company that caused that illness. And if that company is a utility company, or if it's your own city, I live in Painesville, so the city manages our utilities. There should be an action on that.
Well,
and if state law prohibits you from getting a remedy, that is something that should be challenged under this constitutional provision.
But you have a problem with that because proving it.
Right. Well, you gotta assume you
Can I address that?
Go ahead.
That notice of liability is a legal binding contract, and it is upholdable in court.
You still wind up in court having to prove it.
Well, what they have to do is they have to prove their innocence. Right? When you start hitting them with these notices of liability, then they have to prove that what they're doing isn't causing harm. But there's a mountain of data that proves that it is. From what we know so far, we haven't had a notice of liability go to court. We've had companies threaten that they were going to go to court with it if they didn't drop the notice of liability. But when people stood on them about it, the companies backed off. They backed off when it comes to notice of liability. So it's a legal binding contract between you and whoever you served it with. And they are required by law to prepare a defense to that. You can't just ignore it.
Go ahead, Brian.
Yeah, Matt, on the property tax issue, one thing that we found out is with the sexennial revaluation, the counties, Lake County paid $1.8 million for a third-party appraiser to appraise all the properties. When we addressed the third-party company, we said, we'd like to see your calculations. They're saying, no, that's all proprietary information. So what we have said to the officials in Lake County, so let me understand this. You paid $1.8 million to a third party that controls our destiny, but is not accountable to us. That seems like what we were fighting with the Tea Party back in Boston back in the day.
Yep.
Am I missing something on that?
No, but I'll say, based on that Adler case, you would have trouble suing for to claim that the taxation, right? The taxation is unconstitutional. Where you may find an opening under this provision of the Constitution to get at some of these third-party evaluators is and we're going to see this happen now, because we already see that the market is flipped. That now we have it's more of a seller's or a buyer's market than a seller's market. The rate at which a lot of these homes are being evaluated is based on the hot market that we had, around the time of the pandemic. And people are not going to be able to sell their homes at the rate that these evaluators value the property at. And then people are going to be, kind of double SOL, because first they're paying more in taxes based on this outrageously high valuation. And then they're going to have to sell their property for less because no one's willing to purchase their house at that high valuation. That might be an injury under our Constitution.
Yeah.
And that may be where you can get at some of these valuators. You valued my property at a higher rate. I now suffered an injury in regards to my inability to sell it at that rate. And hey, maybe you should pay the difference.
What do you think? The Ohio revised or the Ohio Constitution has been changed 174 times.
Yep.
I always thought of the Constitution as sort of the bedrock, the rock solid. But when they're using it like the Ohio Revised Code, that seems to me like it's defeating what the purpose of the Constitution was.
It essentially devalues our Constitution. One of the things, again, people don't know, when the Magna Carta was first passed, there was a requirement that in every single city and village, every single church, actually, twice a year they had to read the Magna Carta. I think it should be similarly, twice a year, there should be a national reading of our federal Constitution and our state Constitution. You know how long it would take to read our state Constitution when it starts reading like a statute book? Maybe by requiring it to be read that often, people would have a little bit more respect for it and treat it more like we treat the federal Constitution, as a higher form of law that doesn't need to get into these nitty-gritty details like a statute, but just talks about our rights. Simply talks about what our rights are and what the government can and can't do. That's all we need in the Constitution.
Isn't there a Constitution Day for schools to do?
It's coming up.
September 17th is Constitution Day for the federal Constitution. I'm not aware of a Constitution Day for the Ohio Constitution. Go ahead.
Couldn't this somehow be utilized to get rid of these chemtrails?
The Empower movement is on that too.
Is it?
Yeah, they have to do another big water and
Yeah, and again, you guys, you have an absolute, talking about those absolute rights. You have an absolute right to your health, to the enjoyment of your property. And one of the things about the common law was that it worked out the balance of those rights. Because just like I use the example of that early case from Massachusetts, the right of that mill owner to build a mill, to operate a mill, to get his income from that mill, he had a right to all those things, just as much as the next door neighbor had a right to enjoy his property without it being flooded. But life happens, and those rights combined against each other. And the common law is a system that is literally over 1,000 years old to work out how those rights are meant to be, how they're meant to be adjudicated when they conflict.
About the meters.
And they're a trusted system, so that if chemtrails are an issue, if these EMFs are an issue, again, we don't necessarily want to be depriving people who are developing those things for a good economic purpose, right? I mean, those chemtrails don't come from nowhere. They come because someone was using them for a commercial purpose, to generate income, which will end up having good downstream effects on the economy and our community, but also, obviously, some bad effects.
So this could be used for COVID problems too, couldn't it?
Yes. That's what I love about our Constitution. And the common law is it does have an answer for everything. We get into the system that the only things that are good are the things that we think of right now, and we can forget about what happened in the past. I like the system of tried and true. that if something has worked for 1,000 years, it can work for another 1,000 years, especially when you had members of our Confederation Congress saying that they wanted it to continue forever, shall forever remain unalterable, unless changed by common consent.
But we're not getting freedoms to decline and refuse without consequences. And that is a violation of our freedoms.
And that's why, unfortunately, we do have to lawyer up and enforce this through the courts. And that's why I'm excited that now that the Ohio Supreme Court has said that they will revisit past precedent, so we have a chance of enforcing our rights under this provision of our state constitution. Yeah.
I think it was 1986 when the tort law reform came into effect.
We've had various tort reforms.
This was for medical liability. Would that supersede something like this?
So there have been cases where those various tort reforms have been challenged under this provision and failed. But again, the key is in those cases, the Ohio Supreme Court was reviewing this provision in light of the federal Constitution. And now that they're opening the box, it's a good opportunity to revisit that and say, hey, Ohio Supreme Court, if you look at the history of this provision, it means something different than what you said it back in the late 80s or the 90s or the early 2000s when various components of tort reform were challenged under this provision. And we should look at it again.
Can we get a copy of what you just showed?
Sure.
As far as
I can send it out.
So don't you think there should be a billboard, call Matt?
Yeah.
You know, Mesney to Mesney, call Matt.
Of course.
Should we have him back again? Absolutely.
Yeah.
We need to learn more. We need to learn more.
I just was watching Senator Johnson do it at one of his interviews, a meeting with a infectious doctor who from Harvard is an expert. Couldn't answer any of his questions about the mRNA. It is just sickening, you know. Anyway, so thank you.
And thank you for letting me borrow your laptop for this.
Will you stick around a little bit?
Yeah, of course.
We ran a little over, but it was very interesting. I was going to say something tonight about Steve Bannon and the war room, and who was there for Tom Zawitowski? Again, I'm urging you all to did everybody get wethepeople.org?
Yes.
Okay, I'm going to ask you, I'm going to make it short tonight because like I said, we went over. Bannon talked a lot about, there was actually a World War II commemoration with China, India, and Russia. That was kind of funny. Isn't it kind of funny?
And South Korea, North Korea, wasn't the little...
And our you want to call them our talking heads, our Democratic talking heads, really touted that. But yet they didn't when Trump had his military parade. But yet they really love their military parade. Bannon's telling us, if you just please look it up on wethepeople.org. I'm urging you because he's asking us to write to President Trump. Like, you know, Israel's a sideshow to a sideshow. Okay? Russia, India, or if I say in China, right now, we are in World War III, right? With the technology. And he's telling President Trump, you need to focus more on MAGA. Even though he's being stopped at every way, which way he can. I'm asking you to go look up Steve Bannon in the War Room. Okay.
The link is in the email that was out.
It is in the email. That's right. Thank you, Debbie. And what he would like you to say to President Trump, because
he doesn't tell you what to say.
Well, that's the beauty of it. He tells you. No, but if you go through his article, he does tell you that there's a sideshow, which is Israel. In so many words, he's telling him to stay out of Israel. And yes, Ukraine's a real thing, but no more Mitch McConnell putting all this money into the Ukraine.
Right.
Please look at this article. I think it's worth reading. You're right, Debbie. You have to read the article. Bannon is telling to Trump, stop looking that way. Look home. And the election in New York City. How do I say his name? Bandani. How do I say the
Bandani.
New York will run the world because New York is such a capital of commerce. If that person gets in, he said, that person will come up with laws that will rule the United States economically. So those are two things that I'm asking you to fast and pray about. There's so much going on right now. I know our heads are just, you know, we heard so much tonight too. But if you have not subscribed to WeThePeople.org, WeThePeopleConvention.org, you need to every day. Every Saturday, you have an hour and a half. Who listens to it every Saturday? I do.
Not every Saturday.
Well, it comes out every Saturday. And what's beautiful is it has little stories on it. You can go to the what minutes of the story that you want. Okay? Tom is a great speaker. We had him. I was very disappointed in our turnout. We only had like 38 people, was it? Who took the where's Bernadette? How many people did we have at the picnic?
About 30 or 40 people.
Okay. Tom is our biggest speaker of the year, and I know July is a rough month. I mean, it's a Saturday and it's a summer. I'm not so sure we should have Tom at a picnic anymore because there's a lot of work that goes into that picnic, and he has so much to say. I'm thinking of moving him to a regular meeting because he's on every Saturday. He has 10, 12 stories. He's met with Trump. He was with Charlie Kirk 2 weeks ago. How sad that is. So, and Charlie Kirk was supposed to be in Cleveland in 2 weeks from now. Did you know that?
Yeah, I did know that.
Yeah. So I'm urging you to go. If he could actually synopsize the week up for you for conservatives and what you should do. But I'm urging you to see what he says about China, Russia, and India together, flexing their muscles at their military parade, letting us know we're the next superpower. United States, stand down. Very interesting. Our next, real quick, I promised to let Linda O'Brien come on up. And your Marcel for
Molly.
Molly, that's right. So you could come on up right next.
Cash Patel said the shooter of Kirk has been captured.
I heard that just now.
No, when was that? Because when I left, it was not.
No, it
Nobody
was
knew.
just now. Like we've been here.
Yeah.
Okay.
Somebody's on their phone.
Yeah. So go ahead.
Oh, yes, immediately.
All right, by show of hands, who lives in the Mentor School District? All right, good. Now, those of you that have raised your hands, number one, I'm going to ask you to vote, but number two, I want you, and I know you already have a sign, but if you would take a sign and put it in your yard. And those of you who don't live in the Mentor School Districts, maybe you could just take a sign and give it to a friend of yours that does live in the yard. Because after 5 years of going to the school board and telling them that they were wrong about everything, I decided to go and join the school board fight from inside. So I'm going to be on the ballot. Now, here's the thing about the ballot this year. There's 3 positions open for school board in Mentor. All right? I have teamed up with 2 guys. That's Bob Izzo. He's the chief deputy for the sheriff. He brings in the law side of all this. Don Schutz, who's a 30-year teacher and football coach, retired. And then so he knows the educational system inside and out. And me, who focused on change management organizationally, we have united our holding hands, basically, saying let's all get in there. We will have the majority, and we will flip this school. Enough of the woke nonsense. Enough of these kids not measuring up in anything. I mean, they're not measuring up in math, they're not measuring up in science, they're not measuring up in literature, and I can tell you that there's almost no emphasis on history, which is why everybody comes to Liberty Camp. So, it's for you in the back. If nothing else, please take one so you know who we are, because people are talking about this, and they've got the leftists feeding them all kinds of lies. Share them with people. We're going to only win this race by a grassroots effort. We're going to only win this race by people telling people why it's important. We've got to take these kids back. It's like that guy, that crazy rapper Diddy. It's not a joke. They are looking forward to a really sad situation. So I'll leave it at that, but I appreciate your time, and I hope that you'll help us in any way that you can. Thanks.
Only, no electronic machines, proof of citizenship, in-person voting, no universal vote by mail, an election day, federal holiday, and results by 10 o'clock. So I came to ask you to sign his petition to get out on the primary ballot next May. For Ohio, look him up. He's a young man.
Here are in the Riverside School District. Okay, a lot more. Okay. I'm currently the Vice President of the Riverside School Board. We have an election coming up in November, of course, and I want to piggyback on what Linda was saying. You know, we've been coming to the Liberty Coalition for many years. That's how I met Linda. Majority in Riverside now, and we're making changes. If they get the majority in Menor, you're going to see big changes there. And I think you're going to see change in curriculum is where it's really needed. And so we need to maintain the majority in Riverside, and we need the new majority in Menor. So I'd just like to pass that on because
One obviously is going to free our homes from government bondage and being rented to the government. So we need help with, we need circulators. You know, we did the first go around, but now we need to really kick it in. We need really a lot of help. So we need not only circulators, we need help getting circulators to get more circulators. So I've got packets here, there's instructions. There's also a lot of them here I can give them to you to start. And again, we need to get all of Ohio going.
The funding for
Well, Chicago who, well, on events though, wait for hours. And I have people that come here every month, they don't want to be remembered with it. It's a great cause.
I'm going to see about these.
Yeah, sure.
So.